morning and welcome to today's webinar hosted by Region 8 chapters of HFMA. The topic for today's webinar is the Vendor Management Rut, getting the most of our collection for your agency partner. I'd like to welcome today's guest presenter, Jerry Pierce. Jerry serves as Senior Vice President of Operations for a professional finance company. He joined the Professional Finance Company Incorporated in July 2018 as Director of Training and Development. Jerry brought a wide spectrum of collection experience in the retail, commercial, government, and medical collection sectors to Professional Finance Company, and in his capacity as Director, was responsible for the improvement of the collector's skills. He currently serves as the ACA Board of Directors for the Colorado, Wyoming, and New Mexico chapters. I'd like to give a warm welcome to Jerry, and I'll pass it over to him now.
Good morning, and thank you for the introduction there. I'd like to start, as the slide on the beginning slide implies, our subject topic today is Vendor Management Rut. Are you getting the most out of your collection agency partner? As an opening thought, I would like to just say to you that we might reverse these. Stuck in a vendor management rut, debt collection services as an industry has changed dramatically in the last 10 to 15 years, and certainly since my start in the industry in 1973. If you think back to 1973, and more importantly to 1977, when the primary regulation governing our activities, the Fair Debt Collection Practices Act, was enacted during the Carter administration, there were no cell phones, email was non-existent, and certainly there was no texting. I think we can all agree that the dynamics have changed and agencies have been compelled to change as a result. The irony is that many agencies have had difficulty keeping up with regulation. When I started here at Professional Finance Company, the American Collectors Association boasted of some 5,600 members. That now has dwindled to 3,900 members, and the primary reason cited for agencies exiting the marketplace is the cost of compliance. When we talk about stuck in a vendor management rut, we are going to be talking about some items here that you may consider controversial. I want to challenge some of the long-standing paradigms that are associated with the bad debt collection services that are affecting you and your patients. I want to confront the paradigms surrounding your third-party vendor relationships head-on and encourage you to at least consider some of the things that we're going to share with you in this slide presentation. Our legal disclaimer, certainly the information is provided for informational purposes. The rest of it I won't go into. This is just, I think it's the standard. We do ask that if you do obtain a copy of the slides, understand that it is the intellectual property of PFC and proprietary to us. It cannot be shared outside of those members who are attending this call here. To get unstuck, the first stop is doing things that got you stuck. Paradigm number one, the thought is agencies are a commodity. And I put all of these in quotes because I wanted it to come from perspectives. By the way, in my 45 years in collections, about 50% of that was spent on the provider side of the desk. So I understand the vernacular. I was a director of customer service at a large healthcare system in Denver, and actually was a financial counselor and a manager of a billing and collections office. Third-party collection services, there used to be the paradigm is that they're no more than a commodity, so cheaper is better. Agencies used to have days of 33 and 50% contingency fees. Those days are long gone. It's understood that given the client's own efforts to reduce expenses, coupled with advances in technology on the agency side of the equation, are creating greater operational efficiencies. So I'm not suggesting that that rates shouldn't go down. You should expect them to go down. But how low is too low, and what makes sense from, and what should you be aware of as you negotiate your rate with your agency? It has been a generally accepted trend in the industry that but few if any agencies are offering any type of pushback or feedback as it relates to rate compression. And in fact, I would even maintain that some agencies may be taking advantage of this rate compression in that they are actually going ahead and quoting extremely low rates, in effect buying the business. That's what is referred to within the industry. It's not something it is something that's frowned on by other agency owners. Then they tailor their effort to the fees quoted. What's lost in all of this, I beg your pardon, is the fact that the fees is that bad debt recoveries are income to the institution. So you have to look at net back to the hospital. If rates are the focus, I will tell you that you are destined to be a commodity buyer for the duration of your career in healthcare, and it's going to be fraught with frustration and frequent changes in agency partners always in an effort to try and improve liquidity, but to little or no effect. Again, you have to tailor those rates to comply with the margins that are necessary to maintain agency operations. So consider the following. I looked at a $1 million portfolio. If a contingency fee is 10% versus a 20% contingency fee, and liquidation is 5 versus 20, that gives you the gross recovery, $50,000 and $100,000. Now, I think it's fair to say that how can you predict that a 20% contingency fee is going to perform twice as effectively? I can't. But we can assume that the margins are the same based on the correlation between the contingency fee and the liquidation percentage. And yet you, the client, actually benefit by getting 78% more back in terms of your actual recoveries. So that's this figure right here, the 45 to 80,000. The difference is 78% for a 50% rate, a difference of 50% in the rate itself. Again, I can't predict that 20% will get you 10 or that 10 will get you 5, but I can tell you that agencies are looking at margins, and the lower the rate, the more that those margins are compressed, and the more difficult it is for them to maintain operations that you are accustomed to when you were paying 15, 20, 22% than when you were paying 10%. Paradigm number 2, the more agencies, the better. It's imperative to have multiple agency partners, right? Competition is healthy. Well, I think that this one's older than the hills, and frankly, it's one of the paradigms that I had a very difficult time overcoming. I worked in the consulting world, and as my experience grew in the consulting world, it became more and more apparent to me that it doesn't make a lot of sense. In fact, what I would suggest to you is that it calls into question your own confidence. Do you really hear what you're saying? Basically, it's saying, I contracted with this agency, but I don't really trust them. So I have to have 2 agencies or 3 agencies that I don't trust equally. It's a paradigm that suggests that you don't trust your own good judgment in selecting a partner, and has a myriad of other issues associated with it. What are those other issues? There's certainly going to be an increased cost internally for you to manage multiple agency partners. You might have to have different personnel. Perhaps you can have one person that can handle both agencies or multiple agency partners, but most healthcare systems actually will have separate liaisons for managing each different agency partner. You're going to have different methodologies. No 2 agencies operate in the same way. Different reports. There's going to be difficulty getting a report that is consistent from one agency to the next. I would also question whether or not you run similar competitions for your other partners. In other words, for your vendors that you buy paper from, those are commodities. That makes sense. But to my feeling is that you're entrusting countless millions of dollars to a partner. Doesn't it make sense to provide, to establish a relationship with one, a maximum of 2? I have my bias is now a single exclusive partner is the better, and it will help you. If your rates are your focus, then this absolutely makes sense, because market share is the best driver, better than competition. If you have competition, there's potential for increased customer complaints. By the same token, in all the years that I ran multiple agency partners, rarely, if ever, did I ever change market share based on the results. If you are not changing market share, then what's the point? And then doesn't it make sense to save the expense and go with an exclusive partner? If you aren't changing partners, how is the agency incentivized to perform better? There's nothing in it for them to perform better if you're not changing market share. And the alternative, partner with an agency based on a patient-centric basis. what would the patient want? What's the patient experience going to be as it relates to your patient, your patient? What is their experience going to look like? Transparency, site visits. Go out there and kick the tires. Do some reference checking. On your RFPs or when you reach out to your agency partners or your potential agency partners, have clearly defined objectives. This is one thing that I think is overlooked often is the analysis of accounts. Number one, what is the industry norm for your type of accounts in terms of liquidation? And more importantly, what does your own analysis of your accounts indicate you should expect in terms of liquidation? We can go to an industry norm, but if you're in a market that is fraught with high unemployment rates, or maybe it's an agricultural community versus a urban community, all of those factors should be weighed in. And so I would absolutely suggest that you weigh what your liquidation expectations are based upon the type of accounts that you have and your own analysis of those accounts. And then leverage your increased market share to drive down rates. Find one partner that fits your facility's goals and run with it. You won't be sorry. Paradigm number 3. Secondary placements are an absolute necessity. The quotes, leaving accounts with an agency for more than 6 to 9 months is absurd. Accounts move to a secondary agency this has actually we have noticed this a lot in the Southeast in our sales effort. There is a misconception about how Medicare accounts compared to balances after insurance or true self-pay in terms of how they have to be moved through the system that has started this paradigm that you have to have a secondary placement. And then, of course, there's natural impatience in terms of liquidation. Liquidation does take time. The irony is it's counterintuitive to both cost reduction and patient satisfaction improvement. If you're concerned about cost and if you're concerned about patient satisfaction, secondary placement is absolutely counterintuitive to both. And then I think the one thing that's very important to point out is when you look at a liquidation rate, if somebody, for example, is accustomed to receiving a 10% liquidation, that 10% liquidation is absolutely realized over a period of 5 years. It does not happen in 1 year. It does not happen in 2 years. It happens on average over 5 years. The ensuing slide actually shows you that. The assumption here is that there's a 20% liquidation on $1 million portfolio. So what they're suggesting here is that you're going to recover $200,000 on $1 million. However, it's going to occur over a 5-year period. Now, the majority of that recovery will occur in the first 2 years. 60% of the 20% will be recovered in year 1, 24% in year 2, and so on. So the end is $200,000 or 20% in total. I think it's also important to point out that consumer payment habits, a lot of folks who I deal with in terms of both training and in sales, when I go out to talk to them, they always are questioning me as to, Jerry, I really worked this account hard. I sent umpteen statements, I made 10 calls, you send 1 notice, and they pay. I don't know if anybody's ever really evaluated that, because if you look at the initial payment trends in an agency environment, you'll notice that a majority of the payments are received from consumers in day 50 to day 90, and then it skips way over to day 180. Why does this happen? Credit reporting and litigation. Those are all back-end processes which will heavily influence liquidation, but it doesn't make sense, and in fact is based on 501R rules and the new FCRA rules. You can't do either until day 180. Accounts being called in the 6 to 9 month period, you are paying unnecessarily inflated rates on secondary placement rates, which are anywhere from 20 to 50% higher than primary. Consider the following. If the rates for the primary placements were 20% and 25 to 30 for secondary, then based on the previous slide, this would amount to a 25 to 50% increase in expenses manifested in the form of higher contingency fees. So if cost is your concern, pulling back accounts at day 180, day 270, 6 months, 9 months is counterintuitive to trying to save costs. And then again, we already cited the reasons as to why it makes sense to leave accounts with an agency for a specified period of time And on the ensuing slide, we'll talk about that. In the alternative, you may want to consider leaving accounts with your primary agency for no less than 2 years. You saw on that slide where we talked about the recovery over a 5-year period. Obviously, the greater majority, 84%, is recovered within that first 2 years. So it makes sense that if you're going to do secondary placement at all, then that you might want to consider leaving it with the primary agency for 2 years and then moving it to a secondary agency. I would absolutely counsel against moving any type of payment plans, legal accounts, or disputes. Disputes is a new one that we added to our list here when we talk to clients who are intent upon moving accounts to a secondary agency. We absolutely encourage them to allow us to retain all disputed matters. There has been a lot of case law around this recently that may be problematic not only for the agency, both the agency that forwarded it and the agency that received it as a secondary, but, and we'll talk about this later, because of vicarious liability, that may be a problem for the healthcare partner as well. You might want to also allow the agency to keep multiple creditor accounts. What does that mean? Not only accounts that link within your own, but any other accounts that the agency has accounts for. It makes sense because otherwise you're going to send it to a secondary agency, which is now competing with your primary agency over the same accounts. And then finally, and I would suggest this in the alternative after 2 years of placement in general, you might want to look at just going ahead and selling the accounts outright to a reputable debt buyer. This is something that had been frowned upon in the past, but there are debt buyers out there with an appetite to purchase medical accounts receivable, and you can structure your contract such that they cannot resell the account. And that protects you and insulates you from any loss of chain of title. It's only going to go from you to your primary to your debt buyer. And I think that way you get cash versus having to wait for a secondary agency to collect that 16% that's left on that liquidation over a 3-year period. Why not get the cash at day 200 and at day, what would that be, 720 if you left it with the primary agency for 2 years? Paradigm number 4, why would I credit report? Credit reporting in my accounts is ineffective and a waste of time. There are many, many agency owners that would agree with you, but for very different reasons. The reason for it is that the dispute resolution process at the agency level has become onerous, time-consuming, and very expensive. It does require, there is CFPB, the Consumer Financial Protection Bureau. If that's not a name that is familiar to you or an acronym that is familiar to you, it will be one that in the not-too-distant future, which will be. They have already exerted some influence on credit reporting in general, stating that no medical debt can be reported for a period of 180 days from date of last charge. There are companies avoiding, there are certainly agencies that would just as soon avoid the risk. But is it really a waste of time? Consider the following. Credit reporting is a passive activity, no question about that, but it absolutely influences liquidation. Personally, here at PFC, we had a major utility company that had historically allowed credit reporting, but they decided to abandon it. The only reason they did so was not because they didn't agree that it might be an effective means to collect, but they had a breach of their own employees' health information by a health vendor, and they said if it can happen to us, it can certainly happen to our consumers. So they made the conscious decision to go ahead and abandon credit reporting altogether. The result, they knew that they would take a hit on liquidation, but at the outset, when they made the decision, they had no idea how much it was going to be. The resultant influence on liquidation saw their average liquidation drop from 15.55% in 2014 to 5.27% in 2017. In terms of dollars and cents, the shift in strategy cost the utility company over $226,000 in lost collections. Again, once it's bad debt, it's revenue back to the company. So that's essentially $226,000 in revenue. That would buy a lot of trucks and a lot of utility poles for any utility company. Nothing else had changed in the way of process, merely the abandonment of credit reporting. In the alternative, work with your agency partner on data quality issues in the dispute resolution process. I think what I hear from clients as it relates to credit reporting is it also is difficult on your side of the equation to manage the process from a dispute resolution process. The dividends of credit reporting do justify the additional work. So what do you need to do? Evaluate your current data exports for all the necessary credit reporting requirements. They're not terribly onerous. You just have to have a full debtor name. You have to have a guarantor date of birth or a social security number. One of the two is now required, a last known address, and an accurate balance. If you're confident that your data exports include this information, then I see no reason as to why you would not want to continue to credit report. I would also encourage you to schedule regular operational meetings with your collection agency partner. Many of our larger clients we have monthly meetings with, and we discuss the credit reporting processes. We also discuss any refinements that we can make to that in terms of lessening the burden on the client side of the equation. Also in those operational meetings, we do cover actual liquidation results and give them a lot of information relative to how credit reporting plays a hand in that entire process. Moving on to paradigm number 5. This is a big one. Legal action on accounts, bad for business. Paradigm is litigating accounts as a PR disaster and is bad for business. On the surface, I would agree that it does appear to be an aggressive. But if you have, and we'll talk about some things in the alternative here shortly, but it should only be utilized, and whatever, you can actually set these requirements with your agency or partner. You should only be using litigation and literally as a court of last resort. If the consumer is apathetic, they're not responding to calls, they're not responding to notices, the consumer is overly resistant to paying, an outright refusal as an example. Maybe the debt is disputed on the basis of a misunderstanding of liability. We see that a lot in cases of divorces, in the case of disputed matters, in the case where third-party insurance is involved. And the consumer has the available assets. These are not individuals. You would not want to sue anybody just for the sake of litigating an account. You would want to sue on the basis of the fact that they have the ability and capacity to pay, but are intentionally withholding payment of that just and rightful debt. And that you've achieved due diligence to ensure the accuracy of disputes, and that you've done some due diligence. You would never want to undertake litigation unless you maintain a intermediate step of being able to look at the account prior to litigation beginning and have an out within the process itself. Consider the following. Litigation is an integral part of the bad debt collection continuum. This is a lengthy slide in terms of the number. We had two hospitals in Nevada. One had a legal strategy, the other did not. The average net liquidation for the hospital that did use a litigation strategy was 10.53 to 12.23. That, by the way, is right, kind of smack dab in the middle of the national average. Hospital B did not have a legal strategy, and their average liquidation suffered at 4.32 to 7.15%. It is also noteworthy to be able to report to you that Hospital A reported no appreciable impact on public relations, as would normally be manifested in patient satisfaction surveys, complaints or calls to you, nor have they fielded any more complaints than Hospital B as a result of litigation. Moreover, Hospital B suffered a large number of documented losses, which we shared with them, wherein the consumer had the requisite means to meet their obligation, but simply refused to pay. And in some cases, even issued a cease communication, essentially cutting off all ability to communicate with that consumer altogether. Historically, on average, only 10 to 15%. We're talking about a very small segment of your total inventory placed with an agency would typically qualify for legal action. Remember, assets are a prerequisite to litigation. However, the liquidation on those accounts, going to full judgment, increases by a factor of 3x to 5x over non-litigation accounts. Clearly, the opportunity when you have wages and assets in the aftermath of obtaining a judgment, it's almost an assurance that you're going to get recovery. Regarding PR, I think that most agencies, those agencies that do litigate, will take full advantage of the right of assignment. So in those cases, you don't really have a PR issue. because the litigation is undertaken in the name of the agency. And they want to do that for multiple reasons. They want to be the single point of contact for the consumer. They want the consumer to understand that they are working the account themselves. And just as importantly, you can bundle accounts together with multiple creditors where it makes sense. And finally, there is the moral question. This is the question, this is what turned on the light bulb where I was concerned sitting on your side of the desk. And that is, what do you tell consumers who struggle to meet their obligations to you, but do, versus those that have the means and refuse and therefore won't? Wouldn't that pose a more significant PR issue if that became public knowledge, that some are being compelled to pay, and the guy and we all have those favorites, the guy driving the Cadillac and holding the money from you is not paying? I think that would be a greater PR nightmare than to litigate the account for that individual who has the available means and capacity. And the alternative, work with your agency partners on a legal strategy that makes sense. Develop an understanding of the legal process. Again, it goes back to the idea of going and kicking the tires, visiting your agency's office, meeting with the individuals responsible for managing the process, establishing a relationship with those individuals. Define some parameters that make sense. Some items to consider might include balance thresholds. At what dollar amount in the aggregate, remembering that multiple creditors may be involved in a lawsuit, does litigation make sense? And that can vary from one institution to the other. What we typically do here is that we'll go ahead and give you your average dollar balance, and we suggest that might be a good threshold to look at, or at least to start with, in terms of establishing a parameter that makes sense. The timing. You want to make sure that the agency and those individuals who are signing off on litigation on your side have both done some due diligence. Have all disputes been resolved? Are all the T's crossed and I's dotted? Identifications of the liaison who will work with your agency partners. Getting necessary documentation. Again, very few out of 100 accounts that we litigate here at PFC, approximately 10% of those result in an answer, and less than 1% actually go to the possibility of trial and having to produce witnesses and business records and so on. And then who will bear the costs associated with litigation? In almost all instances, agencies usually will bear the full cost of the court costs associated with that litigation. However, if you back out during the middle of litigation, that is something that you might want to explore. Most agencies would require that at that point in time, if you choose to back out in the middle of litigation, that they would require that the client would actually pick up those costs. And then monitor the effectiveness. Agencies can produce any number of reports that will demonstrate to you visually through graphs and raw data as to how many accounts, how much your liquidation is impacted by an effective litigation strategy. And then also look at your patient satisfaction. Are they going up or down? If you haven't ever litigated accounts before and you're installing it, what impact does it have, if any, on patient satisfaction? I would defy any patient to file a bad review just because of a litigation account for an account that they owed. I think that would be a bad idea on the part of the consumer, and they'd be exposed. And then a paradigm 6. It's their problem now. This one I characterize, I signed the contract. Now it's in the collection agency's hands. I have enough to do without having to watchdog my agency partners. It is critical. It's a new day and age. I mentioned to you at the outset of this presentation that 1977 was when the FDCPA was enacted. That is a law that it's definitely stood the test of time, but it definitely needs some retooling to address issues relative to email and texting and cell phones. It is critical for you. Even though we're living in the healthcare world, it's critical for you to understand the regulations and rules which impact agency operations. Why? 2 words: vicarious liability. This is one case that we're citing here. There are multiple cases. Mano versus Healthcare Revenue Recovery in Florida. It was a class action suit with vicarious liability against the provider for collection calls. The court determined that the medical provider had a liability for TCPA violations if calls were placed on their behalf. Whether that's an EBO that you're using, whether that's a collection agency that you're using, you do need to understand those rules and regulations that that agencies operate under. Agencies, conversely, need to understand those rules and regulations that you work under, and we do. The good news is that we understand HIPAA. We understand red flag rules. We understand 501R. We have to. If we're going to serve the medical community, we have to understand those rules and regulations which impact your operations. Conversely, it's important for you to understand as well. So consider the following: managing your agency relationships. There is a fine line. There is what could be characterized as too much and too little involvement. The good news is that they do define this, both in the FDCPA and in the CFPB charters. Too much influence would be exerting too much influence over the operations of your agency partner, such as directing the content of communications, requiring that payments go to your own lockbox, or not allowing the agency to settle, or maintaining control over the payment negotiation process. Again, I don't think the settlement matter is something that's a little bit dicey there. Again, agencies do not generally, when you're signing an account on a trust relationship, on a contingent arrangement, they do not own the account. They should have an obligation to communicate any settlement offer. But if you're not monitoring what an agency does when a settlement offer is tendered by a consumer to them, I think that's a bad idea. You need to understand what your agency does for all of these things. What's too little? The Consumer Financial Protection Bureau defines this as oversight. That is, you must know the policies and procedures of your agency partners very well. It's not acceptable for you to accept merely the existence of a policy, but you have to have oversight into its cause, its effect, and its enforcement provisions. You need to understand those policies because that's what they're looking for, is you need to manage your agency partner or subject yourself to vicarious liability. Failure to maintain a proper level of oversight has the potential of drawing you into any lawsuit your agency partner becomes a subject of. And consumer advocacy groups are looking at this. They're watching for opportunities to broaden the scope of their lawsuits. The good news is that most agencies, they are definitely scraping the bottom of the barrel. These consumer advocacy attorneys, you patch the dike in one area and then the whole spring's loose in another. That's where we're at with that. Consumer advocacy attorneys are looking to work their way up further in the revenue stream for class actionable accounts that they can work. So what could you do in the alternative? Protect yourself. You have to retool your RFPs, and you have to establish some method for ongoing oversight of your agency partners. It should be a part of your revenue cycle continuum. You should have some of your own policies and procedures that actually address your vendor management program. Your RFP process should be retooled so that's more than just a Q&A. You should include site visits. That certainly would go into and document that site visit. You should have interviews. When we have, as an example, we have on site visits, we have credit reporting agencies that show up here on a periodic basis to take pictures of our security, what are our security for the building, what is our security for, what is our recycling policies, on and on and on. You should be just as concerned about those things. Interview the agency partners. Do some reference checking. Overview of their policies and procedures. So when you're talking about your RFP, ask what the policy is and ask for them to attach a copy of the policy if they, understanding that the NDA is already in place generally, but ask for that. Track their historical record with the Better Business Bureau, with the Consumer Financial Protection Bureau. All of these are public databases that you can easily access. What is their track record with the State Attorney General's office? What does their complaint resolution process look like? How do they investigate consumer complaints? Do they have a mechanism for consumers to complain at all? Schedule regular calls with your agency partner to review your complaint data. Understanding that in some cases you're going to have to take ownership of your own side of the street and exert some influence and move to correct issues that are occurring on your side that are impacting operations on the agency side. And so you need to correct those to avoid further occurrences and track their effectiveness. And then avoid exerting too much control. Don't dictate payment policies or entertain dialogue. This is a big one. I think the biggest one that I can tell you is to the extent that you can. I mean, you can't cut off all communications with patients. I understand that. But to the extent that you can, trust This goes back to having a trusted agency partner. Understand that you should revert or redirect that consumer once it's been placed with the agency directly back to that agency partner. The right thing by you, that they're going to do the right thing by the consumer, and that you'll have a win-win situation. Questions? What ruts are you in with your current vendors? Any questions at all?
We have a couple actually.
Okay.
Here's one. It says, do you have any healthcare examples where discontinuing credit reporting impacted liquidation rates?
On healthcare?
Mm-hmm.
We do have some, yes, we do have some partners that are not, it really depends upon, we have a duty to any individual, any client that comes into the offices that tells, we have a standard set of protocols that we go through. They can opt out of credit reporting. We do have a select few that do, and they understand that liquidation is going to be impacted as a result. And I will tell you that they, on average, the results that you saw for the one utility provider are similar to those that you would find for in healthcare as well. So for healthcare providers that are not credit reporting, hospital typical liquidation rates are between 12 and 15%. If they're not credit reporting, that's running more in the area of 5 to 8%. For those, in terms of the physicians and other medical practices, their liquidation rates are running anywhere between 18 and 25%. With, again, understanding that that's with credit reporting. If it's without credit reporting, they're about half that. So what we do in our implementation and boarding process is we go through that with them. We do explain our credit reporting process, and then, but the decision ultimately rests with the client. I would absolutely, positively advocate for credit reporting in almost all circumstances.
Okay, thank you. And then I'd like to remind everybody that you can submit your questions using the questions chat panel located to the right of your screen. And we'll take as many as time allows until the end of the hour. Also, we have another question. What criteria does your agency use to determine a patient's ability to pay? How you accurately score them?
That's a great question. We do. It's a twofold question. We have some inclination of a consumer's propensity or ability to pay at the outset of the accounts being listed. We do some scoring. We do collectability scoring. The scoring that we use, we have used multiple vendors over time, but we have settled upon one. Again, advocating for a single partner. We have and the reason we settled on the one was all single collectability scores include in their model the ability to look at payment history and credit reporting data. However, the differentiator with the vendor that we're currently working with is they bring in and introduce socio-demographic information. What that means is that they actually will look at it, as it's been explained to us, and why they're so effective, is that they are looking at the zip code where the consumer lives. And they know the approximate mean income in that particular area. They know the percentage of homeowners versus non-homeowners. They know they still look at payment and credit history, but they introduce this socio-demographic. So that's one element. The second element is through our call efforts. We do conduct, if a consumer, if we're able to contact a consumer, we do go into and they need a payment plan. We do a full and complete. We actually ask them questions that you would be accustomed to hearing for when you're being interviewed for credit. So we ask them, where do they work? What do they do? And then we come up with a reasonable payment plan. So we have some idea if that payment plan ever defaults as to what they're doing. And then lastly, we work with a couple of niche vendors that work in the employment verification space, bank verification space, and home ownership verification space. These are vendors who are experts in those fields, and when we identify that one of those assets exists and our overtures to reach a mutually agreeable payment plan with the consumer fail, then we proceed with the next logical step, which is litigation. Hope that answers the question.
Okay, thank you. And then another, why do you have credit agencies visit if you aren't using credit to determine how to score a patient? And they said maybe they misunderstood and thought you said you don't agree with using credit when determining who to collect from?
We do not. I think credit is only one indicator of a person's ability to pay. Like I said, the vendor that we use that does our collectability scoring looks at the socio-demographic, the credit bureau history, and their payment history in general. That could be both credit and history that they may have historically captured as a result of working with multiple partners. So credit is just one facet of predicting a person's ability to pay.
Okay, and what are some risks associated with second placement of accounts?
Some of the risk associated with second placement is certainly from a patient satisfaction standpoint. If it's too quick, you're actually countermanding imagine for a minute, if you received a notice from a collection agency and are not convinced that you owe the bill, you're going to question that bill. If a hospital is pulling the accounts back too aggressively, that dispute may not have been resolved and could end up with another agency, and the consumer has to start over. That is a problem from a consumer satisfaction standpoint, and it's certainly a problem from a liability standpoint, a risk. In that balance, that was a disputed matter. The new agency is unaware of the dispute, and now you have a problem with trying to collect on a disputed debt. That could, if the consumer attorney gets wind of the fact that you're aggressively placing second placing accounts, not allowing for that dispute process to resolve itself, then you're going to have a problem with vicarious liability purely on the basis of the fact that you send the account to a secondary agency. There are other risks associated, but that's one of the high ones, the disputed matters.
Okay, thank you. And then I think you kind of answered this one in the earlier question, but what is the typical liquid rate of primary collections and or secondary collections?
Yes, primary liquidation does vary based upon the class of business. So hospitals are going to be in the 12 to 15% range. Some are higher, some are lower, depending upon the demographics, urban versus rural, a number of different circumstances that can influence that. But on average, 12 to 15%. Your physicians, your medical, your ancillary services are slightly north of that. You're going to typically be anywhere between the 18 to as high. I've seen it as high as 30%. Once again, that is going to be based upon average balance, type of practice, is it self-pay versus a balance after insurance, and so on. Secondary placements, again, that's one of the other reasons I think secondary placements are so counterintuitive. The average liquidation rate for secondary placements is anywhere between 3 to 5% across the board. And as I mentioned, I would advocate that you leave it with a primary agency for a minimum of 2 years, and then you look to sell it. Get the money from a reputable debt buyer rather than having to wait out the additional 3 years for the balance of that liquidation to occur.
Okay, thank you, Jerry. I think that's all of our questions for today. I'd just like to thank you again for such a great presentation. We had a lot of interest in this topic, and I think a lot of people were very engaged in the presentation and slideshow itself. So I'd like to thank you again for that. And as we approach the top of the hour, I just want to take a minute to thank all of our members and healthcare community for joining this call. As you exit, you'll be prompted with a survey. We would appreciate you sharing your feedback about today's event, as well as what kind of topics and other things you're looking forward to in the future for some of our future webinars. If others viewed today's webinar with you, we would also like the chance to provide us with their email addresses so we can receive their credit information and credit you for today's educational webinar. And thank you again, Jerry, for being our guest speaker for today.
Thank you.
And thank you. Yeah, and we'd love to have you again on a future webinar. And thank you again on the behalf of our Region 8 chapters of HFMA and everyone for joining us today. And I hope everybody has a great afternoon.
Thank you.